Hearing in the appeal, Secretary of State for Work and Pensions against MM.
Well, I will do as I always do, where there is a reporting restrictions order. Just to remind everybody present that the court has ordered that no one shall publish or reveal the name or address of the respondent, who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the respondent or of any member of his family in connection with these proceedings. I say that because, of course, we are live streamed and it is very easy for people to forget anonymity orders unless I stress them. So that's number one. Number two, we know what the representation is, so there's no need for you to tell us, but it's good to see you all here. We've been thinking about this. The outcome of this appeal is going to be some direction or other to the tribunal, because it's common ground the case is going back to the tribunal, as to how they should approach this question of whether what is required is simply prompting or whether it amounts to social support. Having started quite a long way apart, you're now very much closer together than you were when you started. So we thought we'd ask you to provide us, before we have the hearing, with a paragraph, it might take two, but it might not, containing the direction that you would like us to give to the tribunal, each of you, preferably showing where you differ. Yeah. Because a lot of it you won't. Would you be willing to go and do that? And we will then adjourn and wait for you to, I'm not sure how long it might take you. How long do you think it might take you?
15 minutes.
My lord says 15 minutes.
Well, I realise it's not a bidding war, but I suspect that might be a little short. Could we say 20 just for the moment? And if we're nearly there...
Oh, we'll settle for 20, I think.
Say 20.
Well, Lord Kerr will settle for 20. I was going to suggest half an hour, but let's settle for 20 minutes.
Perhaps we can let you know.
Let us know if that's not adequate. But you see what we're getting at.
Is the intention that the proposed direction deal both with the question of the qualitative issue, as we've phrased it?
Yes, or there's both the qualitative and the timing issue, both of those. Yes.
Thank you very much.
Because those are the 2 points where you are slightly at odds with one another, but so very little.
The timing issue, there is quite a big divergence.
Yes, that's true. Well, we would like, that's why I said it might be 2 paragraphs, but we would like to have some clear, focused language for us to think about. 20 minutes. Yes. Well, has this been of any use whatsoever?
Yes, it has. The focus is what's the difference. You'll see that we have 3 proposed directions, distilling it down to its very basic aspects. Firstly, does the claimant need prompting, assistance or supervision from a person who is trained or experienced in assisting people to engage in social situations? In considering that question, the FTT must consider what help is needed and whether it needs to be provided by the supporter by reason of their training or experience. And 3, in order to qualify under the regulations, the social support must be needed for at least part of the activity.
That's the temporal requirement.
That's the temporal aspect, yes. The position of the respondent They say that the question for decision in relation to activity 9C is or should be simple and straightforward. Does this claim need help from a person with training or experience to be able to engage with other people? That is the only direction that they say is necessary. The next two parts is more explanations, I think. So the test has to be capable of being addressed by lay claimants, potentially with mental health difficulties without representation. It should not require detailed elaboration. That's obviously not a direction. Yeah. The difference between 9B and 9C is that the claimant needs help from a person with training or experience, which may be derived from assisting that claimant. I'm not sure if that's a direction, but it's an explanation. And then the present tense needs supports refers to a present need, but the support need not involve physical presence and may be given in advance. So the disagreements between the parties are whether all social support has to fall within supervision, prompting and assistance, that's the construction point. Whether support needs to be by reason of their training and experience. And 3, in relation to timing, whether social support can be provided in advance and whether it must also involve physical presence for at least part of the activity. And then mine's proposed direction is set out at the bottom. Yep. FTT should establish whether the claimant needs social support. Social support may consist of prompting as defined. I think we all agree about that, provided that it comes from a qualified person. A person such as a relative will be a qualified person if he or she is experienced in assisting that person to engage in social situations. The requirement that social support described above is needed. No further gloss is appropriate or helpful.
Well, that's very close to the respondent's position.
It is. They take no point on the timing issue.
No point on timing, yeah. Right, well, that's helpful, if not productive. So,
well, the training or experience is disjunctive, and mine's proposed direction that he or she has experienced assisting that person to engage in social situations would seem to come under the rubric experience. Would you accept that?
That it would appear to come under the rubric of experience?
Yes.
Yes.
So someone such as the respondent's partner would qualify.
Yeah.
A respondent's partner could qualify,
Yeah.
yes.
That's always been common
position.
ground, as I understand
That's always been, yes, that's right.
Because in all the explanatory, preparatory materials, it was accepted that it did not have to be a professionally qualified person. Experience would do.
Yes. The reason that we say that the focus in our second proposed direction is necessary is because there is a real concern that when somebody says, we think it's important that whoever's making the decision focuses on the reason why it needs to be that particular person. Not because they love them or they trust them or they're familiar. It's because they're experienced. Now, there obviously may well be an overlap between all of those things, but the question is whether it is by reason of the experience as opposed to some other close relationship or connection.
Right, well, you better possibly, as we have interrupted your time, or at least the collective time,
yes.
We hope that this would help to focus the discussion. So perhaps you better get on
Thank you.
Explaining to us why you think that the language needs elaborating in this way.
Yes. Does my lady Lordship need to take you through the legislative scheme at the outset? I'll do that very briefly then.
I think we know the legislative scheme. I think what we need to get onto is the precise meaning of the regulations.
Fine. It's necessary then to start with the structure of the activity and the descriptors within it. The regulations are in tab 2, MS number 333. A claimant scores no points if they can engage with people unaided. That's descriptor A. It follows that if a claimant fits within the descriptors 9B or 9C, that the claimant does not, obviously not fall within descriptor of being unaided. The definitions of aided and unaided are mirror images of each other. These are set out earlier on in the interpretation section at MS 328. Aided means with the use of an aid or an appliance, or supervision, prompting, or assistance. And unaided is on MS page 330, the last definition, means without the use of an aid or appliance or supervision, prompting, or assistance. Being unaided, therefore, means without the use of an aid or appliance or supervision, prompting, or assistance. So help provided under 9B and 9C must therefore, in principle, and subject to any other limitation, either express or implied, we say, amount to a form of aiding. 9B limits the form of help needed to prompting, and 9C refers to social support. Because this must constitute a form of aiding, the nature of the help provided must be either the use of an aid or an appliance, which by nature it isn't, or supervision, prompting, or assistance.
And what difference would that make? I mean, assistance is a very wide term.
No, because those terms are all defined.
Right.
So assistance is defined on page 328.
Physical intervention.
Yes, physical intervention by another person and does not include speech. Prompting is defined on page 329, means reminding, encouraging, or explaining by another person. And then supervision is defined on page 330 as meaning the continuous presence of another person for the purpose of ensuring C's safety.
So in the definition of social support, does assisting people have a different meaning from assistance in the same set of interpretation provisions?
I don't think it's not limited, it can't be limited to physically intervening, because otherwise you couldn't have prompting to be included. It would then be limited to a physical matter. So when one's looking at the concept of engaging face-to-face, which you may have followed from the statement of case, and this is not controversial, engaging face-to-face is not defined in the regulations themselves. What is defined in the regulations is engage socially. That's on MS page number 329. Engage socially means interact with others in a contextually and socially appropriate manner, understand body language, and establish relationships.
And do you say that engaging face-to-face is the same as engaging socially, or do you say it's narrower or wider?
No, we say that it's the same. And the reason for that is the historical drafting.
Yes, it's a hangover from the drafting.
Yes,
Yes.
that's right. It's set out.
And that's not contentious.
That's not contentious.
No.
It's not contentious that it means the same.
It's not contentious that this freestanding definition, engage socially, which doesn't relate to any other provision in the regulations, should have effectively been changed when the
Should have been
activity-
changed to engaging face-to-face.
Yes.
So it was a drafting slip.
Yes, and the reason, as we've set out in our statement of case, that engaging socially, activity 9 was originally called engaging socially.
Yes.
Yes,
And there's-
we understand that.
There was a history as to why it was changed to engage face-to-face.
All I was wanting to find out was whether it is common ground that actually they mean the same thing, because normally when different language is used, different things are meant.
Engage socially as a freestanding phrase may not mean the same as engaging face-to-face, but the definition underneath it applies to engaging face-to-face.
Is that common ground? That the definition of engaging socially actually applies to engaging face-to-face because the department made a slip in amending the changing the draft. It's not common ground, but
If it is accepted, we say that yes, it is, and I can take you to the case law that establishes that in due course if necessary. In fact, let me just then refer you briefly.
well, no case law establishes anything in this court
that's
unless
true.
it's the case law of this court. So
Fair enough.
it's of limited value to us. I mean, it may be absolutely correct, and if you think the reasoning is unassailable, then no doubt you'll draw our attention to it. But
Is the expression engage socially used elsewhere in the regulations? Not at all. That's a good starter for you.
It is. Maybe I can just refer you to one passage.
I'm also not quite sure why it wouldn't be in the respondent's interest to say that that definition applies. Certainly to my mind, the idea of engaging face-to-face is a narrower idea than engaging socially. I appreciate that's more a point for the other side when they get on their feet, but I ought to mention it.
Thank you. Well, I mean, like I said, engaging socially may be seen or as the two words themselves as a broader concept, but it's the definition underneath it that applies here rather than the words engaging socially. Let me just find the relevant passage. I can't lay my hands on that at the moment. But the reason why it was changed is set out at paragraph 60 of our statement of case. It's MS 157.
Sorry, give me that number again, please.
MS 157 as written case, paragraph 60. And so the explanation was that engaging socially was really engaging with other people face to face. And the explanation is some respondents have noted their concerns that the scope of this activity is too limited. They suggest it should include additional elements, for example, physical barriers to socialising with other people, such as being able to get to social situations. These concerns reflect a misunderstanding of the purpose of this activity, which is not about assessing overall ability to maintain social relationships or activities, but to look at whether they have difficulties with the mental and cognitive elements of social interaction. To make this clearer, we have renamed the activity engaging with other people face to face. And further at paragraph 61 of our written case, the activity was designed to focus on mental and cognitive ability and as such may apply primarily to individuals with mental, intellectual and cognitive impairments. We do not consider this inappropriate because barriers to participation caused by inability to engage with others can be significant, and it is important that these are taken into account. We consider that as a whole, the assessment does take into account the full range of barriers that individual faces, regardless of impairment types. So that was the reason that it was changed, and then the case law, which I obviously isn't binding but explains it, is at MS page 151, paragraph 40. And the So, so in the context of engaging face-to-face, social support may involve supervision or assistance as defined. This is not likely to be the most common form of help. It follows that most of the time, social support will involve prompting. And if it is accepted that social support may be prompting, the next question is, what is the difference between descriptors 9b and 9c? Social support is defined in the regulations as support from a person trained or experienced in assisting people to engage in social situations. And the terms of the descriptor itself require this must be needed for the person to be able to reliably engage face-to-face. And the reliability criteria are in Regulation 4, which basically means safely to an acceptable standard, repeatedly and within a reasonable time period for over 50% of days. I would suggest it is uncontroversial that the starting point is to consider what the claimant needs in order to be able to engage reliably with other people. If they simply require reminding, encouraging or explaining, so the definition of prompting by another person, which could in theory be delivered by a non-trained, non-experienced person, then that's prompting. However, if C requires reminding, encouraging or explaining in order to engage face-to-face with others, which by its nature can only be delivered by someone who is trained or experienced, then that constitutes social support rather than prompting. Now, we say that it's implicit in, it flows from the requirement that the social support as defined is needed for the claimant to be able to engage face-to-face. And what they need is that support from a person who is trained or experienced. Why? Because it's by virtue of that training or experience. And so the requirement for training or experience by its nature, we say, means that the provider must be doing something that is more specialist, reflecting the claimant's higher level of need. And we would say that those words, trained or experienced, indicates a qualitative difference in need resulting from impairment, which is greater than that referred to in 9b, which is just prompting, which is not required to be given from a person with particular training or experience. And the qualitative difference between the two is that the trained or experienced person understands, because of their training or experience, what is lacking in the engagement and is able to fill that in or enable the person to fill that in for themselves. So an inexperienced, albeit well-meaning person would not necessarily be able to see what is lacking in the engagement, anticipate a difficulty or know how to remedy it. As we set out in our written case, I think it's paragraph 84 of 162, it is accepted that friends or family may fall within the definition of a person who can provide social support. And that's accepted, but it needs to be by reason of their experience. The respondent submits at paragraph 20 of their written case, that's MS 179, that the Secretary of State's approach to the construction of Activity 9 is wrong. She argues that the structure of Activity 9 does not require social support to be constrained within the definition of aided, because that would confine social support to some form of supervision, prompting or assistance, which is our case. She suggests it's capable of wider definition. However, the respondent gives no example which would fall outside those three categories. And the examples that she sets out: physical intervention to draw the claimant's attention to the need to engage, potentially amounts to assistance, we would say, as defined. Physical intervention to distract may also do so. The example of a physical intervention in order to assist the claimant to withdraw from a distressing encounter may also amount to assistance.
Maybe the extent of the difference between you depends on how widely you read prompting, because it's got rather a wide definition. And it has to be wide enough to allow for somebody with training to use their training to good effect.
Yes.
So would you agree that it has to be read quite widely?
Well, it's got to be read in light of its statutory definition.
Well, we've got that. It's
Which is
reminding, encouraging or explaining.
That's right.
Which is a wide category of things to do.
It is. And
I'm
that's
struggling a bit to see what the problem is between you with regard to this.
my learned friend objects to our focus, our approach, which is to say, work out what the person needs. Does it need to be given by a person who's trained or experienced by reason of their training or experience? That's the bit that they object to.
But is that not what the Inner House has already found in paragraph 55 of its opinion? I mean, I'm wondering, you're challenging the Inner House, but I wonder if that's what they've already said. In our opinion, the critical distinction between prompting and social support is the fact that social support comes from a person trained or experienced in assisting people to engage in social situations. That does not mean, as the argument is somewhat unkindly parodied in some of the cases, that prompting qualifies as social support merely because the help is in fact given by a person trained or experienced in assisting the people so to engage. It's the next sentence. There has to be some necessity for the help to be given by a person with that the training and experience. Isn't that very close to your case?
It is close, but then the opinion goes on to say there may be, sorry, let me just find it. There may be cases, so further on in the same paragraph, where the support is of nature of encouragement or explanation, but because of the claimant's mental state, it will only be effective if delivered by someone who's trained or experienced in delivering that type of support. In such cases, there will not be a qualitative difference in the help given, but the help can be regarded as support because of the necessity for it to be provided by someone trained or experienced in delivering it. And the concern is that by saying that there's no qualitative difference between the support, one detracts from the requirement that it is given by somebody who's trained or experienced by virtue of their training or experience.
Thank you.
And the problem can be seen at paragraph 23 of the respondent's case. Because at paragraph 23 of the respondent's case, the respondent accepts that it must be correct. Let me just find it. it is correct to draw a distinction between the need for a trained or experienced person, which will bring a case within 9C, and a need for a familiar person who does not require training or experience. We agree, which will not satisfy the descriptor. It is important not to lose sight of the point that experience may be gained in the course of relationship. We agree with that. But at 24, the respondent says, this case, the present case, provides a helpful illustration. It is, inter alia, his partner's familiarity with the respondent that allows her to know when he needs support in an engagement. She is familiar with the triggers for his anxiety responses and how such responses start to manifest themselves. He would not be able to engage at all if he did not have the confidence that she would rescue him if an engagement was becoming too difficult for him to manage. And here, the respondent has fallen into the language of familiar. And familiar and experience are not necessarily the same. One can be familiar with a person and their condition, but not experienced in how to support them. And it may be that what is being described in paragraph 24 is actually experienced, and that so the word familiar is a misnomer. But our proposed direction 2 will help everybody to focus on what it is, so that being familiar on its own is not the test.
Well, there are two concepts in paragraph 24. First of all, familiarity, and secondly, rescue. Didn't have the confidence that she would rescue him. That surely implies that by dint of her familiarity, she's in a position to well, I'm not sure rescue is quite the word that I would use, but assist him.
Help him.
So you're happy enough with, provided both of those dimensions are present, familiarity and help.
Well, familiarity doesn't have to be present, of course, because the help might be provided by somebody who's trained.
Right. Well,
So that my point is that familiarity is one of these concepts that people use as a shorthand, but it tends to lead everybody a little bit up the garden path.
yeah. Well, if we're dealing with experience rather than training, if we're concentrating on experience,
Yes.
then familiarity surely is a necessary ingredient. And if you combine familiarity with the ability to help, that surely constitutes all that is required, doesn't it?
All you need is to be experienced.
Yes,
And you will, in every experience, you will be familiar. That's true. But familiarity is not enough.
But this lordship isn't suggesting that it is enough. It's saying the combination of familiarity and the ability through that familiarity to spot the triggers and thereby assist.
Yes.
These are components and perhaps the whole content of experience.
The intervener's position is that the gloss, by reason of the supporter's training or experience, is artificial and confusing, although they appear to agree at paragraph 21 of their written submissions that it must be by reason of the supporter's training or experience. Although that's how we've read their paragraph 21. So our criticism of the inner house's approach is that it confuses or is liable to be applied by decision makers in a manner which risks confusion between people who require support from a person because of their relevant experience and those who require support from a friend or family member solely because of their relationship with them. And the distinction is between those who need help from an experienced friend or relation by reason of the helper's experience, rather than solely because of the relationship with the helper. And then we go back to the criticism, which I think I made briefly before, which is of them saying that the court saying there will not be a qualitative difference in the help given, we disagree. If there's a need for help from someone experienced, it follows that this is because the helper uses their special knowledge gained from experience rather than training in judging what help is required, thus leading in some way to a qualitative difference. And the second criticism is that the court considers that prompting can qualify as social support if, to render it effective or increase its effectiveness, it requires to be delivered by someone trained or experienced in assisting people to engage. We submit in our written case that this first focuses on the wrong question. The question is what is required for the person to engage with other people reliably for more than 50% of days, and whether effectiveness is increased is not relevant. And so that's why we get to the concluding paragraph in our case, which is that we say that when considering whether a person's claim under Activity 9 falls under 9B or 9C, the correct approach is to identify what help is needed,
I'm so sorry, where are you now?
Yes, I'm just looking, I'm sorry, I'm just finding the reference. 91.
Paragraph 91 is
paragraph
MS 165.
91, yes. 91 MS 165 is to identify what help is needed in order for the individual to be able to reliably engage, determine whether that help needs to be given by a person who is trained or experienced in assisting people to engage, and if so, determine whether that help needs to be given by that trained or experienced person by reason of their training or experience. Familiarity is not enough. So those are submissions on the first point.
I'm still not entirely sure why that doesn't marry up with what the Inner House said at paragraph 55. Even in the last sentence of paragraph 55, the court is still talking about there being a need for support. It has to be provided by someone trained or experienced in delivering that support. So they're not saying familiarity is enough.
No, but they do say in the same sentence that there's no qualitative difference, and that causes a concern because they don't also say that the necessity for it to be provided by a person trained or in delivering it by reason of their experience or training. They don't say that, so it leaves it too open-textured, we would suggest.
Right, but I mean, on the absence of qualitative difference, I thought that you accepted that prompting can, in some cases, amount to social support, so there is an overlap between the two. I appreciate you say other things have to be in existence as well.
No, even if it's just prompting, we say that it's more specialist. It's still
Right.
prompting, but it's qualitatively more specialist. It reflects a higher level of need and can only be provided by somebody who's trained or experienced. The words might be the same, but the time that you utter them or the way you steer someone away from a situation may be different.
You say it's got to be supervision, prompting or assistance, and given the restricted definitions of supervision and assistance, it's most often going to be prompting. This is a very different case from the one that the department originally ran, is it not? But nevertheless, you've got to that point, and that's where you are. So what you're basically saying is it's a different sort of prompting.
It's a more specialised sort of prompting.
Yes, there has to be some necessity for the help to be given by the person with this training or experience, which is the sentence in 55 of the Inner House, which you don't object to. It's the your real objection is the assertion of no qualitative difference.
And some necessity is also a gloss by the inner house, because it has got to be needed. It's not some necessity.
If you reformulated it to something like this, help of a kind which can only be given by a person using training or experience, and then the bit about the type of training or experience, would that cover your problem? A person using training or experience.
Would you mind saying that again?
Of course. Help of a kind which can only be given by a person using training or experience of the relevant kind.
Yes, I think.
Because I'm getting confused with your B and C.
Yeah.
And I'm trying to put it into a much simpler proposition. Do you want me to read it again?
No, I think that's.
Yes.
That's.
I mean, I'm
yes.
finding difficulty in understanding what C adds to B, which I think is what my lady is.
That's what I'm trying to put into one sentence rather than... So it was help of a kind which can only be given by a person using training or experience. Because you're not looking at the actual help that the person is calling upon at the moment. You're looking at their need, aren't you?
That's right.
So it's the help that you're looking at rather than the person.
It's what that person needs.
The help they need.
Yes. In order to be able to engage.
So the help has to be effective.
I don't know that I think it doesn't necessarily have to be effective,
Well, it's got
does
to
it? But it has to be of a type that can only be given by a person with the relevant experience or training.
Well, that's true. That's true for. The difficulty is that once you accept that 9C, that prompting can be, that 9C social support can be just prompting, then what's the difference between the two 9B and 9C? And the difference is that it's got to be provided by a trained or experienced person. That's
Yes.
what's needed. And we say by reason of their training or experience.
Yes, because you don't want the, let's take it out of the family member who's just affectionate. Let's make it a family member who happens to be a psychiatrist. But they're not actually deploying that skill. They're deploying their familiarity with the person.
Yes.
That's what you want to cut out, isn't it?
Yes.
So it is the fact that they are using the training or experience in this setting
Yes.
to give the help.
Yes.
But the experience could be professional experience,
Could.
or it could be the experience of a friend or family member
Personal.
who is very, very familiar with the peculiarities of the particular person concerned and the difficulties that they have. It could be either of those sorts of experience, couldn't it?
It
You
could.
accept that?
I accept that. And I think some of the examples when the matters were being developed was looking at young autistic adults, for example, who may have very special or particular requirements in relation to engaging face-to-face that could only be provided by, for example, that young autistic adult's mother, because she knows him extremely well. She knows exactly what his triggers are. She knows the signs and tells of some sort of panic attack, or that he would react in a certain way.
It's getting very difficult to understand the difference between you all on this. Very, very difficult.
I
think I've understood what it is about paragraph 55 that you object to.
In relation to timing, and then if I can turn to that point. So as you'll see from the proposed direction, it's our submission that social support should be contemporaneous with the face-to-face engagement being supported. It does not include help provided on some other occasion in advance of the social engagement. We've set out 5 reasons in our written case. These start at MS page 165, paragraph 93. The first one set out is that the assessment is a calibration of functional limitations at the date of the claim with the application of qualifying periods. So we didn't go through all the legislation, but if you look at tab 4, tab 4, MS, page 354, section 77 sets out the allowance known as PIP and explains that there are two components and you can receive either or both. Section 78, page 355, is the daily living component with which we are concerned here. And 78.1, a person is entitled to daily living component at the standard rate if a person's ability to carry out daily living activities is limited by the person's physical or mental condition, and B, the person meets the required period condition. And then the same is true for section 78.2, a person is entitled to the daily living component at the enhanced rate if A, the person's ability to carry out daily living activities is severely limited by the person's physical or mental condition, and the person meets the required period condition. Subsection 4, daily living activities means such activities as may be prescribed, and subsection 5, sections 1881, see sections 1881 for provisions about determining whether the requirements are met. Going then to section 80, this sets out the requirement for whether a person's ability to carry out daily living activities is limited by the person's physical or mental condition, or severely limited, that's A and B, is to be determined in accordance with regulations. So whether a person's ability to carry out daily living activities is limited or severely limited is to be determined by regulations themselves. And then subsection 2, regulations must make provision for determining, for the purposes of each of sections 78 and 79, whether the person meets the required period condition. See further section 81. Regulations under this section must provide for the questions mentioned in subsections 1 and 2, which is whether you're limited or severely limited, to be determined on the basis of an assessment of the person, or repeated assessments, and must provide for the way in which an assessment is to be carried out, and then may make provision about matters which are or are not to be taken into account. And then finally, section 81, the required period condition. Regulations under section 80, subsection 2, must provide for the question of whether a person meets the required period condition, to be determined by reference to whether, as respect every time in the previous 3 months, it is likely that if the relevant ability had been assessed at that time, that ability would have been determined to be limited or severely limited. B, whether, as respects every time in the next 9 months, it is likely that if the relevant ability were to be assessed, that ability would be determined to be limited or severely limited by the person's physical or mental condition. So the assessment, the question is whether or not somebody has a limited or a limited or a severely limited ability to undertake daily living conditions. That's to be determined by regulations, and those regulations must set out the assessment of the person's ability to undertake the activity in the regulations with the application of qualifying periods. So that's the first point. The second point is when the term social support is properly understood by reference to the definition of aided, the use of the present tense in the 9C descriptor supports the construction that the supporter must be present for at least part of the activity. The test in 9C is whether the person needs social support to be able to engage with other people. And therefore we say that that clearly suggests contemporaneity, and in the case of engaging face-to-face, we suggest also physical presence. Now, the respondent relies on the legislative history to say that this was expressly considered and rejected. That is their statement of case, paragraphs 30 to 31, MS 183. But on analysis, that's simply not correct. And in fact, the legislative history and the documents demonstrate that the clear intent was that unless supervision was required, and that's of course defined as continuous presence throughout the whole of the activity, for other forms of support, the help had to be provided by a person for at least part of the time that the activity is undertaken. So, could I ask you to turn up tab 16, which is the first draft of the regulations. It's MS 536. The relevant page it starts at 544. So the interpretation schedule refers to aid or apply. Refers to assistance, which is the second definition, and it's the same as it currently is. And it refers to prompting, which is over the page. Is it? Oh no, it's slightly different. Prompt means remind or encourage, and references to prompting are to prompting by another person, but broadly the same. Supervision is not there at all. Instead, the daily living activities on MS page 546 qualify prompting and assistance by reference to two timing definitions. One is continual and one is intermittent.
Sorry, where do we find this?
So if you look at MS 546, look at 1B, can buy food and drink only with continual prompting. 1D, can plan food and drink only with continual assistance. And then 3D, for example, can take nutrition only with intermittent assistance or prompting. And those terms were defined, if you go back a page, MS page 544, as continual, meaning throughout the entire duration of the activity, and intermittent meant for at least half the duration of the activity, on the bottom of page 544. And every reference in the schedule to prompting or assistance, which were the only two terms, is qualified by the word continual and intermittent. And this was explained in the technical note which accompanied the draft regulations. That's at tab 17, MS 562. At paragraph 615, support from other people, middle of the page, The assessment will take into account where individuals need the support of another person or persons to carry out an activity, including where that person has to carry out the activity for them in its entirety. The criteria refer to two types of support. Assistance is support that requires the physical presence and physical intervention of another person, i.e. actually doing the task in question. This specifically excludes non-physical interventions such as prompting or encouragement. And prompting is support provided by reminding or encouraging an individual to undertake or complete a task but not physically helping them. It again requires the physical presence of an individual, so telephone prompting is not considered. 6.16, in both cases, the amount of support required can be continual, where the person providing the support must help the individual for the entire duration of the activity, or intermittent, where the person providing the support must help the individual for over half the time that the activity takes to complete.
Could you help me as to where, I know that there was a change in the way that they dealt with this, but there's only one thing I can find, which is an engaging socially provision, and that is under 9B of the first draft.
That's right.
So the sort of situation that is now being looked at in the new 9 isn't within this.
No. So what happens, and as we set out in our case, the communicating with others activity underwent quite a lot of revision, and it was eventually split into two different activities: one communicating with others, and two engaging face to face.
But the engaging face to face bit emerged from not being able to do it at all, which is how it was in the original regulation, into varying degrees of inability. And so you're trying to rely upon the use of the words continual and intermittent in this original draft as supporting it needing to be actually now whilst it's happening. But the concept changed into something much bigger when it went into the new regulation draft, didn't it?
That is accurate, that's true. But if you follow it through, and I'm going to show you, you'll see in my submission, you will see that in fact it is clear from the intent all the way through that any help provided throughout the act, provided for the purposes of undertaking an activity, had to involve help at some point, at least at some point during the activity. Now, this provoked a range of responses in the consultation, and a summary of those are found in tab 19, which is, sorry, let me just check, at tab 19, MS 617. So the document at tab 19 is the independence, the second draft of the assessment criteria. It's the explanatory note to the second draft. And at page 617, the government responded to the concern. So at 617, it sets out the objections that many respondents felt that the definitions of continual, intermittent were difficult to apply and the thresholds were too high. Some felt, 314, that the focus on support was too physical, and it was questioned at the last sentence, it was questioned why the use of assistive technology, including telecare and telephone prompting, was excluded. And 315, strong concerns were raised that the proposed approach did not look at support required from another person, did not capture the requirement for continual presence of another person to ensure the individual's or others' safety, similar to the concept of supervision within the disability living allowance. And the response to that, sorry, and the response to those concerns is in the same document, MS 633. Paragraph 418. at 4.22, we received strong feedback that the proposed approach would result in individuals with significant barriers being inaccurately assessed. In particular, respondents were concerned about the omission of the concept of supervision, the high thresholds for intermittent and continuous support and prompting required physical presence. In light of these concerns, we have substantially revised the approach in the second draft of the criteria. The terms intermittent and continuous have been removed, and the descriptors now refer only to assistance and prompting. Furthermore, such support now only needs to be required for part of the activity to apply. This is a significant difference from the thresholds for intermittent, for over half the time taken to complete the activity, and continual, the entire duration of the activity used in the first draft. We recognise, for paragraph 4.20, that there are numerous different ways in which an individual could require prompting to ensure that they carry out the prescribed activities. In light of this, the definition of prompting used in the second draft criteria does not explicitly require the presence of an individual, of another individual. However, such prompting must be essential for the activity to be carried out. And then over the page, 634 at 4.22, the broader definitions used in the second draft enable the assessment to reflect support required from another person more accurately, requiring support for only part of the activity and taking account of the need for supervision should ensure that the assessment better captures the impact of impairments. And that's obviously exactly what happened in the second draft of the regulations, which are in tab 18. And the relevant part is at MS 595, which is the schedule. And you see the introduction there of supervision on page 596. The definition of assistance and prompt remains the same. And it's also in this second draft of the regulations that you get for the first time the definition of engaged socially, page 595.
We see its context in heading 8 and 599.
599, yes.
Engaging socially.
Yes.
Heading 8.
Exactly. So by the second draft of the regulations, they look substantially the same as the last draft for the purposes with which we're concerned. And we say that the response to the concern was to take away the requirement that presence had to be, if it was not continuous, it had to be for over half the duration of the activity. That's the change. It's about the amount of time you are providing support during an activity.
But it took away that requirement without explicitly saying, but they have to be there for some of the time.
Well, it didn't say it. That's true that it didn't say it in the regulations, but it does say it in the explanatory note.
Yes, and what are we construing?
Of course, but I'm asking, and I understand that, but this is one of a number of points that, taken together in my submission, show that the intent was that it should be during part of the activity, and it's a response to my learned friend's suggestion that it was dropped on purpose so that it meant it could be provided in advance. And then finally, the policy intent was made further clear in the final consultation response in December 2012, when the final version of the regulations were also published. That is in tab 23, so that's the second volume of authorities. at page 793. Is that right? Under the heading Supervision, Prompting and Assistance, paragraph 4.28 sets out the context. Comments and government response at paragraph 4.30. Several respondents argued that divining supervision from another person as their continuous presence throughout the task was to prevent a potentially dangerous incident occurring was too high a threshold. Sorry, that's not the relevant paragraph, my apologies.
Yeah.
It's paragraph 4.33 over the page. We received various comments from respondents stating that where prompting and assistance are referred to in the criteria, they should apply for some of the time rather than the majority of the time. This is in fact the policy intent. One of the changes made in the second draft of the criteria was that in order for prompting or assistance to apply, it simply had to happen at some point during the activity, not for most or all of the time. There are also no longer any references to intermittent and continuous in relation to support. And so we say that the policy intent fits with the overall structure and the purpose of the regulations, which is to determine entitlement on the basis of an assessment, and that the assessment is a calibration of functional problems at the date of claim with the application of qualifying periods. We say that it's an assessment of the actual disability during the activity, not of the level of prior involvement required to get the person to the stage where they can engage. And that is the view, certainly, of one upper tribunal judge, and if I could just point that out in the explanation at tab 7, so volume 1 of the authorities bundle. It's MS, it's paragraphs 56 and which is 57, sorry, paragraph 57, page MS 397. 397.
97.
Yes, 397. MS page 397. You'll see from the previous paragraph at 56, the question that she's setting up to answer. I agree that social support can be provided by friends or family, but does the mere fact that the support is given by experienced friends or family or a trained person convert what might otherwise be covered by the definition of prompting into social support? And does social support have to be available at the moment of the face-to-face engagement? It's that aspect that I'm asking you to focus on. 57, some upper tribunal judges have decided that therapeutic work done with a person to enable them to engage socially at some later date is sufficient to engage activity 9C, for example, the case of PR. To my mind, that a person has had or continues to have such therapy may be a helpful indication of the severity of their condition, but it cannot of itself be taken into account to score points under activity 9. The specialism of those providing such services in advance cannot, in my judgment, amount to social support within activity 9, which relates to a need for help while the activity is being carried out. 58. In all other activities in the schedule, the attention is given to the disabled person as it is being undertaken. Whilst activity 9 is more nebulous than others, that does not necessarily demand a different approach. To restrict the attention to matters done in the physical presence of the claimant is logical in respect of the schedule as a whole. The converse approach where behind-the-scenes support is considered poses real difficulties as to the extent to which the historical assistance can be included. The assessment is a calibration of functional problems at the date of claim with the application of qualifying periods. It is an assessment of the actual disability during the activity, not of the level of prior involvement required to get the person to the stage where they can engage alone. And
Can I just ask whether on your interpretation, sitting in a room next door and thereby giving confidence pursuant perhaps to a session that's taken place, would that be sufficient?
not for social support.
Right.
What sort of professional help do you think is contemplated?
Social workers or others who are specifically trained to deal with people with mental or cognitive difficulties in relation to face-to-face assessment. It might be a district nurse, it might be social workers with expertise in certain kinds of conditions.
So what sort of things would they do in practice? Can you give us a sense of what a trained person might do on your interpretation of the regulations?
A social worker may accompany an individual to the local community centre and stay with them and remind them that if somebody comes up to them or touches them by accident, that it's not aggressive, and that they don't need to panic. They might pick up on signs that the person is becoming particularly anxious, which, for example, they know could cause an outburst or some sort of violent response. Those sorts of things. I can probably get more detailed examples.
Care assistants.
Pardon?
Care assistants, would they count?
Yes, potentially, yes.
Yeah. Teachers?
If they are providing the prompting, providing support to enable face-to-face engagement, yes. If they're providing teaching in advance to teach somebody a set of techniques so that they can manage their own anxiety and engage in face-to-face activity on their own, then no. Because the measurement we would submit is to get the person through the activity. It's not about
It's almost as if the more skilled professional help the person has needed, the less likely it is to qualify. Because what is going to qualify is something at a much lower level than skilled therapy or skilled education, something to get them through the moment, which is likely to be somebody at a much lower level of skill.
But,
that may not be a criticism, it's just a comment.
Yeah, but there are other sorts of therapy provided, such as physiotherapy, to enable somebody to regain the use of their hands so that they can take nutrition unaided. Doesn't fall. The person wouldn't score any points for that. So it is part of the structure of the regulations that therapy provided in advance of the activity of itself does not mean that you score points for it.
But it seems to be two parts. It seems to be the time element and also the presence actually in the activity element that you're saying have to exist. Is that right?
I am for social support, so there is the it has been conceded generally it has been conceded that prompting, not social support, but and I'll come to social support in a minute, but prompting given immediately prior to the activity.
Well, it would have to, wouldn't it?
It would, because how would you, well, exactly. That's right.
And actually, if we start to look at the other activities where supervision or prompting are involved, like being able to wash or bathe, you wouldn't be saying that the prompting had to involve being there.
Doesn't have to involve being, no. So
So-
exactly, hence the.
So prompting's a bigger, wider concept, except where it features in social support. Is that the...
No, it's that prompting can be given immediately before the activity. It's time for dinner, have some dinner, you need a bath, get into the bath. But
Go in there and talk to these people?
that might be prompting. But when we're talking about social support, because of the hierarchy within the activity, it represents a person who has a higher level of need, and when you're focusing on the ability to respond to a face-to-face engagement, it would mean that the person needs to be there.
But that is an assertion. It's not something that appears in the regulations itself. That's
It doesn't.
the difficulty.
We're construing the regulations. The policy intent may be one thing, but it's the regulations and what they say that we're trying to make sense of.
Yes, but I can see that prior therapy, which meant that at the time of the encounter the person was able to cope, could be outside the scope. But I would have thought that prompting, which had a close temporal and causal link to performance in the encounter, might be within the scope of the wording of the regulations. Now, I see that the Inner House have used temporal or causal, which they've borrowed from a tribunal judge, I think. And that seems to be problematic, because if it was merely temporal, what would it be offering if there was no cause? But would it cause great difficulty for the government if the regulations were construed as requiring a close temporal and causal link between the prompting and the actual encounter?
Yes, because the intention was that the support, we say, had to be provided at the time of the activity.
That's not quite the question. You've told us what the intention was, and we are used to policymakers telling us what the intention was. The question for us is always whether they actually carried out their intention in the legislative scheme. And my Lord's question was, would it cause you difficulties? It wouldn't coincide with your intention, necessarily, assuming you're correct about that, but would it cause you difficulties?
It would increase the likelihood of arbitrariness. It makes the criteria more difficult to apply. And it would be very difficult to assess which form of support provided in advance was relevant and how far back that goes. Increasing the likelihood of different views. And there's a separate problem relating to friends or family members. It's well established, which is our fifth point in our statement of case.
This is MS 167.
Yes. So paragraph 101, on page 167. that it is well established that a friend, family or other lay person can provide social support as long as it's established on the facts that they're experienced, and the rest relates to our submission on issue 1. Where friends and family are relied on as the basis of the social support, it would be difficult or indeed impossible to distinguish between the moral, social and emotional support as an ordinary incident of such relationships and the type of assistance designed to equip someone for a social encounter which might qualify for C. And we've also submitted it becomes very difficult to ascertain how far back one should go. It would be impossible for a decision maker to draw a consistent distinction on when counselling sessions need to occur in relation to the activity. It also creates potential difficulties in assessing the required period condition. And so, for those reasons, we say that it must be present for at least part of the activity. And the difference between prompting and social support in this aspect is that although prompting, because when it's social support, it's more intensive and more specialised, and given the nature of the activity, which is engaging face-to-face, we submit that a person needs to be physically present in order to be able to see that engagement and respond accordingly. So the difficulties then, the test propounded by the Court of Session, and we said perhaps as in our statement of case, that the use of or is confusing, and the test is inconsistent, and by introducing the idea that of a temporal link other than the actual presence during social support is sufficient, it increases the likelihood of arbitrary decision making. Unless there are other questions, those are my submissions. If I could just turn around.
There are no other questions, Ms. Broadwood. Thank you very much indeed. Mr. Komorowski?
My ladies, my lords, I have nothing further to add.
Thank you. Yes. Scott.
Lords, it's the invitation of the respondent that the court should dismiss this appeal, and that the eligibility for 4 points under Activity 9 should be very simply stated. And the court has my written note of the question that I proposed: does this claimant need help from a person with training or experience to be able to engage with other people? Except that social support is defined in the regulations as support or help from a person trained or experienced in assisting people to engage in social situations. But as I mentioned in the note presented in writing to the court just this morning, an applicant has to be able to address this test for themselves, and that applicant will be usually a non-lawyer, and in this particular case, in relation to Activity 9, is quite likely to have mental health problems, and is likely to be required to state their case unrepresented. And I note that in the Hickey case at tab 9, at MS 419, the Court of Appeal declined to deal with similar issues to those which arose in the present appeal because, and I'm reading now from paragraph 48 and the last few lines, unlike M, therefore, this is not a case where the points now argued were taken fair and square by the applicant at the outset of the proceedings. Instead, I consider the claimant's case has been continually reshaped over the years in an attempt to rely on developments in the authorities referred to above.
I'm sorry, where are you?
Which paragraph?
Paragraph 48, last 4 lines.
48, last 4. Thank you.
And of course, what Lord Justice Coulson is doing there is criticising an unrepresented, mentally ill person for failure to take all points fair and square. And Swanson explained to Lord Justice Coulson that M, the respondent in this case, didn't take all points fair and square. The points were taken actually by the upper tribunal judge, who put them into issue in referring the matter back to the first tier tribunal, because there will be very few such claimants who will be able to take these points fair and square, which is why the plea for the respondent, and indeed echoed by Mind, is for a clear, straightforward, comprehensible test. And in opening, I do refer the court to the severe criticism of the UK made by the United Nations Committee on the Rights of Persons with Disabilities, examining the UK's implementation of this legislation and what was actually happening to claimants in the course of these applications. I'll pass rapidly over the establishment of the inquiry and so on and take the court immediately to MS page 1153 in tab 30. The committee observes that persons with disabilities who'd undergone functional assessments aimed at determining their eligibility for social
Which paragraph
benefits.
is this? Sorry.
90, my lady.
90, sorry.
90.
Yep, thank you.
These persons felt they were merely being processed rather than listened to or understood, and then there was an assurance given that matters had improved. And then the evidence collected from various sources indicates that needs, views and personal histories of persons with disabilities, and particularly those requiring high levels of support, such as persons with intellectual and or psychosocial disabilities, were not properly taken into account or given appropriate weight in the decisions affecting them. The inquiry collected evidence indicating that information, advice and counselling provided to persons with disabilities on the different steps in the assessment processes and decisions on their entitlements were limited, non-existent or not provided in accessible formats and languages. That was coupled with uncertainty about outcomes of those processes, triggered anxiety, psychological strain and financial hardship. The committee also collected evidence about persons with disabilities whose mental health condition had severely deteriorated as a result of the factors mentioned above. So there is evidence before the court that this is not working, and it's the respectful submission on behalf of the respondent that in part it's not working because it's been made too complicated. And if there's any indication of that, it's perhaps in the cases which were incorporated in the final supplementary bundle, and I just refer the court briefly to the cases at tabs 32 and 33, These were cases incorporated at the request of Mind. Tab 32, 2 points given to a person who was a selective mute with social anxiety, couldn't make eye contact, couldn't read facial expressions, didn't understand body language and became so anxious that he had an open sore on his hand and he bit himself and lashed out. And he was given 2 points. And in 33, a lady who couldn't bear social contact but went to the pub where she spoke to nobody and had the usual, was given no points. And so we clearly have got matters in my submission and our submission too complicated. And it's about, this issue is about real people with real disabilities. And if I might be permitted just to spend a short time on the respondent whose case this is, and who is not able to be here because he does have mental health problems. He suffers from anxiety and depression. He avoids social contact. He can become completely panic-stricken and very distressed.
Is he able to watch us online?
I think he is watching it.
Well, I just thought we should acknowledge his presence if he was.
And indeed, that of his partner is also unwell today. So I'm grateful, my lady. That will be appreciated. Now, the partner gained her experience in dealing with people who have anxiety and depression in looking after other close relatives. And she learned a number of techniques, and I'm going to mention them because they're illustrative of the sort of issues which the court is dealing with. One of those techniques is named by the partner as a worst case scenario, which she helps him with in advance of engagement. They look together at what is the worst that could happen in the course of this engagement and how he would deal with it. And that gives him the reassurance that it might not be quite so bad and he can manage it. And I understand that's a technique which is regularly applied by professionals such as community psychiatric nurses in advance of engagement. That's the sort of support that is being looked at here. When the respondent and his partner are actually in the course of an engagement, she monitors him for triggers. In particular, the subjects which are likely to cause him stress, so she can redirect the conversation. If she sees his anxiety levels rising, she will intervene. And given that he is a person who is depressed, that affects the accuracy of what he's able to say. He's liable to acquiesce, and his memory is affected, and she's able to assist him with that. They use private signals, a tap or a hold of the hand, to reassure him and allow an engagement to continue. And I have an issue about whether reassurance is encompassed in the assistance, prompting or supervision that is described by my learned friend Mrs. Broadfoot. She might have to extract him. She has a strategy she uses with him, which she describes as a 5-point strategy. He becomes panic-stricken. She gives the indication, and the 5-point strategy is he focuses on 5 things he can see, 4 things he can touch, 3 things he can hear, 2 things he can smell, and 1 thing he can taste. And by the time he's done that, some of the panic has diffused. And then he relies on her to take him home, absolutely exhausted. But they can discuss the engagement, how it went, and what could be learned from it. But that, in my submission, illustrates something of the potential breadth of social support. Now, he rarely goes out without his partner, but he does very occasionally. And one of the things he goes out for is for his cognitive behavioural therapy. She can't go with him, it's one-to-one engagement. But her preparation for it, particularly the worst-case scenario technique, is very important to allow him to attend that therapy. And if he didn't have her, and using her skills to help him, he wouldn't be able to engage socially at all without overwhelming psychological distress. And one of the huge frustrations of this case is that when his partner accompanied him to the decision maker in the first-tier tribunal, she felt she was shut down, that she wasn't given the opportunity to explain all this. It wasn't thought to be relevant. And so there they are, living experience of the findings of the United Nations Committee on the Rights of Persons with Disabilities. And here they are, thanks to the upper tribunal judge who saw the point. If I might then move on to some general points about activity 9. It's my submission that the regulation requires to be construed in its terms. But if one wants to look for a purpose for this regulation, I would submit we could identify the purpose as promoting social inclusion by providing a benefit to cover the cost associated with disability, using a set of criteria as a proxy for cost. As the court has already discussed with the learned friend Miss Broadfoot, there was a development of this regulation over the course of its genesis. And it might be worth just looking very briefly at that genesis, starting at the initial draft regulations, and I appreciate we've looked at them already, and therefore I'll be brief with this. Tab 16. MS 548. Where engagement socially was a subset of communicating with others, and the only part of social engagement taken into account was a complete inability to engage socially. And as Lady Black has discussed with a friend, that was the context for this intermittent or continual prompting. It doesn't relate at all to what we now have in the current version of the regulation. That then developed in the second draft of the regulations in tab 18. And MS 599 to engaging socially. And we see there the familiar now familiar four parts of the activity there as activity 8 and under the heading engaging socially. But that, of course, was broadened, as we see and have already discussed in the final version of the regulations, tab 23, where there was a response to consultation. And we've already looked at this, so I can be brief. It's at MS 8113 to 8115.
Sorry, the MS number?
813 to 815.
813, 815, thank you.
The section covers engaging socially and starts with the original version, or the second version rather, of the activity. And at the end, it sets out the new version, which we've had in the regulations. And it moves from engaging socially to engaging with other people face to face. And in my submission, that reflects, in its terms, a broadening of the range of activities and interactions, because if one's engaging with other people face to face, that is not just a social occasion, because it will incorporate matters such as formal interview, medical examination, forms of therapy, thinking of the respondent's CBT. It may encompass a learning environment. It may encompass securing services, as well as social occasions which may be large or small, including, as Lord Glennie points out in the Quarter Session Inner House opinion, engaging one-to-one, and I'll come back to that. And so my submission, with the broadening of the title to the regulation, we see a more generous approach to its application, and indeed that is what this consultation response says at 502. It was suggested we include some differentiation in this activity to establish whether individuals...
Sorry.
5102.
5102.
Yes, I'm so sorry, 5102.
Paragraph 5102.
Yes.
Yeah.
Indeed.
Yeah.
It was suggested we include some differentiation in this activity to establish whether individuals have difficulties engaging with different people, such as people who are familiar or unfamiliar, or different sizes or groups. However, we believe that our approach is more generous, not by differentiating in this way. We are establishing difficulties with engaging with other people generally, and thereby encompasses a wider group of people. Of course, if one's going to achieve the purpose of promoting social inclusion, that is necessarily so, and this activity is necessarily there. And it does mirror what we see in the United Nations Convention on the Rights of Persons with Disability, not just in Article 19, which covers inclusion, but also inclusion in terms of exercising legal capacity in terms of Article 12.3 of that convention. It's difficult to see how this activity could be narrowed given its purpose in terms of the UK complying with rights under the convention.
In other words, if you're going to function as near to normal as possible, your interactions will be in situations that could not properly be described as social.
Indeed.
Not always, anyway.
Indeed.
And you need, if you're going to be a a functioning individual, you need to be able to interact with someone on the basis that you're buying something or receiving some service from them and so on.
Indeed, indeed. Or being interviewed for a position. There are, or for that matter, conducting, and I'll come to this, romantic engagement.
Yeah.
Which is why, in my submission, the attempt to prescribe and narrow this down is difficult in the light of our convention obligations or the commitments we have given by ratifying the convention.
Of course, social doesn't have to be narrowly defined anyway.
No.
Social doesn't have to mean social in the sense of recreational. It can mean
Any encounter.
an encounter with other people.
Indeed. The difficulty, of course, has been that in the attempt to keep the activity limited, there's been a tendency we see in the upper tribunal decisions on the basis of submissions on behalf of the present appellant to narrow this down to something which is as limited as it could reasonably possibly and perhaps not reasonably possibly be. That's the concern about adding riders, limitations and so on, which appears to be part of the appellant's strategy, albeit changing in the form of the appellant's case. Now, that takes me to the substantive issue of what is involved, the qualitative issue in Activity 9C. And I adhere to my straightforward and simple question about this. And it's a matter of note, possibly regret, as the issue originally raised by the appellant was an assertion that social support did not include prompting. And we see a series of cases from decision makers on the basis of submissions made on behalf of the appellant that have used a sort of subtraction approach. Take social support, subtract prompting, and see what's left. And if there's anything left, you give it Activity 9C. And that was the approach taken by Judge West in the case in tab 3 and Judge Gray in the case in tab 7. And it was indeed the position of the appellant before the Inner House of the Court of Session. We now have the converse of that, where we have the appellant asserting that most of the time social support will involve prompting. Now, what that means, of course, is there are numerous PIP claims that have been refused on a basis which is now represented before this court to have been wrong. And if we look at why that has happened, in the respectful submission made on behalf of the respondent, that's because decision makers have, with encouragement, departed from the question and imposed an elaboration on the terms of the regulation, which is now accepted cannot be supported. And that's why, for the respondent, we go back to a question in simple and straightforward terms. And I would submit that the court should resist the temptation to chase around this regulation, trying to construe one term by reference to another. Because if, as Ms. Broadfoot represents to the court today, virtually everything can be taken within supervision, prompting or assistance, then there is no point to chasing matters into whether this is supervision, prompting or assistance. On the other hand, if the motivation behind that is to try and limit matters into supervision, prompting or assistance, and at some future stage say reassurance is not social support, then we're back to where we are today in terms of limitations, artificial limitations being imposed. And there is a liability in requiring that exercise to confuse decision makers and claimants. And one can illustrate that by the discussion that the court had with my learned friend in relation to assistance. Because if social support is assistance, Then, of course, assistance, as it is now defined in the regulation, involves physical intervention and does not include speech. And so rather than having a broad definition there, we have a definition which chases the matter back, away from social inclusion, away from the focus on the needs of the applicant, the claimant, into what I would respectfully submit as an esoteric argument which doesn't actually achieve the object and is inconsistent with the terms. Social support is social support. It's the need for a person with training or experience to help that individual engage with other people. And then if I might turn to the issue of whether we are looking at the nature of the help. In my submission, we're not looking at the nature of the help so much as the nature of the need. And there are two problems with the submission, that there is a different nature of help between, let's say, prompting and social support. The first is that there is an inconsistency in the argument that accepts that support may include prompting. In other words, the nature of the help may be exactly the same. And it overlooks the point that the difference lies in the need for the help to come from a person with training or experience, because the trained or experienced person will know what to do and when to do it. And if I might be forgiven for recounting the old story of the plumber who was called to deal with a problem with pipes, looked around for 10 minutes, and then hit a pipe with his pipe wrench 3 times, upon which everything started working again, and delivered a bill for £100. And when his bill was queried, he said that was £5 for hitting the pipe and 95 for knowing where to hit it. And of course, it may be an old story, but it does rather illustrate that the social support might be exactly the same thing as prompting, but it's a question of knowing when to do it, knowing exactly what to do at that particular point to assist the person who's making the claim. Now, I'm conscious of the time. Is that a suitable point? I'm still in the middle of qualitative issues, but I can carry on after lunch.
That seems a very convenient moment, if that suits you.
Indeed. Indeed.
Well, we'll adjourn now and resume at 2:00. Thank you.